Good day and welcome to another episode or a session of Lunch and Learn. Today we will be discussing how to conduct a Section 6 maintenance inquiry. And joining us today will be Advocate Reuters. Welcome, Advocate.
Good afternoon to our viewers and listeners, and welcome and thank you, Eugene.
Fantastic. So today we will be discussing, like I said, Section 6, and we'll define what is the role of the maintenance officer. We'll be discussing, what is it that the maintenance officer needs to establish when it comes to a complaint, some clarification on what is considered to be care and a caregiver, as well as just a general outline of what to expect at court pertaining to the Section 6 inquiry. We'll be discussing consent orders. We get that quite often. And just what happens if the respondent do not show up in court, and what happens if he is not bringing, or he's supposed to be in court and he's not bringing all the documents. So we'll be addressing all those type of issues. So just in order to clarify, what to expect from this webinar, if you have pre-registered, then you would have received a link to log on to our website where you can find the live stream. You would also have access to some pre-reading material as well as a resource and templates tab. Now, under that tab, all the case law, all the examples, all the documents that we will be referring to during this webinar will be downloadable from that tab. But without any further ado, I think we can start off with, and just Advocate Reuters, just as an introduction. Section 6 is the topic of today, and how to conduct the maintenance inquiry. So the statutory provision that we have is obviously Section 6.1, where it says that any person legally liable to maintain any other person, or if there's good cause for a substitution or discharge of the order, then they can approach the maintenance officer that will investigate or shall investigate the complaint, and then obviously proceed with it further. So that is the statutory provisions that we have regarding that. So as a starting point, we all work with the maintenance officers in the different courts, and sometimes there is every court has a maintenance officer, or sometimes they simply don't. What is the qualifications of the maintenance officer? Just to give some context to the listeners out there.
Well, a maintenance officer is a person that is appointed in terms of the Maintenance Act, and that is in terms of Section 4(2) of the Maintenance Act, that you get the DOJ maintenance officers that most applicants will meet at their first interaction with the criminal court or the magistrate's court. So that is the person that they will meet in the maintenance officer's office, and that person is appointed in terms of Section 4(2) of the Maintenance Act, and they are being appointed by the Department of Justice. But the viewers should also take note that a prosecutor that is appointed at any court is also deemed to be a maintenance officer. That's in terms of Section 4(1) of the Maintenance Act.
So in other words, if you have a rural court that is in the Bundus and they do not have a maintenance officer, then the prosecutor would be deemed to be the maintenance officer of that court.
That is correct, Eugene. And there is a case that we will refer to a little bit later where a prosecutor unfortunately did not know that in terms of Section 4(1) he is deemed to be a maintenance officer, and told an applicant that no, she must come back when the maintenance officer is at court, while he himself is the maintenance officer. So a maintenance officer includes a public prosecutor and not the Department of Justice's maintenance officers only.
And then just the qualifications of the maintenance officer. They're not just normal clerks. They do have a legal qualification, and it's one of the prerequisites for their appointment. That is that they should have at least an LLB degree. Is that correct?
That is correct. The maintenance officers that the Department of Justice appoint are all legally qualified people with legal background, that is an LLB, and they will then fulfill that duties of a maintenance officer that is then in the maintenance legislation.
Good. We've established now, okay, so they do have a legal degree. So what do they do? What are the duties of the maintenance officer? Just in general, just short, just a couple of thoughts regarding that.
If you look at Section 5 to 7, 5, 6, and 7 of the Maintenance Act, you'll find there's a lot of duties that is being shared amongst both the maintenance officer and maintenance investigator in conjunction with one another. The maintenance officer do not just do things in silo. You will consult with the maintenance investigator. So the maintenance investigator is deemed to investigate the complaint on a recommendation or on the mandate of the maintenance officer. So the two of them work hand in hand. As soon as the applicant files a complaint, she will then give certain information that will be followed up and investigated by the maintenance officer by giving instruction to a maintenance investigator. So his duties is, or her duties is, to investigate that complaint and then to find out whether there is a Section 2 relationship and whether there's a duty to maintain and whether there are means for that specific respondent.
Okay. Section 6 makes a reference and says that the maintenance officer must investigate as soon as a complaint is laid in terms of Section 6.1. But they certainly do have a discretion later on to say, but you know what, this is not a valid case. Then they do have a certain kind of discretion that they could utilize.
That's true. In a case where the specific person or the respondent do not have the means, then obviously they will then have further decisions that they can make, whether to add the respondents, which is the grandparents or whatever the case might be, or the person do not have the means, or the person's DNA do not match the child's DNA, and therefore is presumed to not be the father in those cases, then obviously there will not be any further investigations that is conducted, and the case will come to an end at that juncture.
Correct. And then sometimes we have complaints regarding the maintenance officers or maintenance personnel. What recourse would the general public have if they feel that the maintenance officer is not fulfilling their duties? What type of recourse would they have?
Well, there is two documents that the maintenance staff have to prescribe to. The one is the DOJ Service Delivery Charter, and the other is the Department of Justice's policy document, that is the Code 26 of 2015, in which the maintenance staff should abide by the policy of the DOJ in order to ensure that no person will be turned away, and they will be assisting that applicant when that applicant is in the maintenance office. The service delivery charter is quite extensive. It even goes as far as saying that within 2 hours, a applicant should be assisted by a maintenance staff member, whether it's the maintenance clerk, maintenance investigator, or maintenance officer. All of them should at least make contact with the applicant whilst that applicant is waiting in the waiting room.
That looks good on paper. It looks good on paper, but it does not transpire in courts, not the courts that I attend to in any event.
I'm in the hot seat today, so yes, I know that there isn't full compliance with that specific service delivery charter. The staff don't even have badges that the service delivery charter recommends, but there's nothing that stops the applicant from asking the staff member, what is your name, what is your email address, and getting that information when they enter into the maintenance office. Yes, there is some of the provisions in the service delivery chart as well as the DOJ Code 26 of 2015 that is not being complied with, but I believe that with Lunch and Learn, if we bring this message to the public and they are informed, then they will know how to be able to assist themselves in future whenever they have to approach the maintenance court.
What we will also do for the attendees, we will have the service delivery charter as well as the DOJ code. We will have under the resource tab. Now, those two documents are not, well, the service charter is available online, but the DOJ code 26 is not necessarily available online, although it is prescribed that it should be in every library at every court. But most of the courts that I've attended to, and you ask them for that, they just give that blank stares. They don't know what you're talking about. But we'll drop that in the resource tab, or there's a resource folder for you to download. I just want to come back to we've defined now the role of the maintenance officer, but I think it's also important just to bring awareness to a very, well, it's basically a landmark case of Omar Anna Mutumunye regarding the delictual claims that they have against the minister when it comes to, non-fulfillment or negligent fulfilling their duties. Can you just elaborate a little bit more on that, and how did that transpire? Just in just a couple of seconds.
Well, this case dates back to 2014 edition, which is 9 years ago. And by now, I thought that the maintenance staff would have learned something based on that specific case. But in this specific case, the public prosecutor that didn't do his job. The applicant was sent from pillar to post every time I had to come to court. Every time she went to court, there was no maintenance officer, only the prosecutor that didn't know that he is deemed to be a maintenance officer in terms of Section 4.1 of the Maintenance Act. And that culminated into the applicant losing her specific rights or her specific attachment of a pension fund. And luckily, she managed to, in the Gauteng High Court, managed to sue the Minister of Justice, and she was lucky in her intellectual claim and managed to claim all the arrears as well as future maintenance that she was entitled to if the Department of Justice, including the NPA, the prosecutors, acted expeditiously in her favor.
So there is some recourse, and the Anna Mutumunye case, which will also drop on the resource folder, is quite a landmark case because it paves the way through for accountability from the state if they do not do their job properly. So what was a maintenance officer first established? And you alluded to that, and you basically said, Akarat, they have to do the Section 2 relationship that they have to do. Obviously, the maintenance process starts with a complaint being laid by the complainant, and then it goes to the clerk, and then it goes to the maintenance officer. Just in general, an overview of a normal Section 6 informal inquiry. Most people, they've heard about that now with Lunch and Learn. They know that it is an informal one. Just in broad terms, in your own words, can you give me your comments on how would you describe a Section 6 inquiry?
Well, to start off with, it's an informal process. It doesn't have to comply with all the legalese and legal jargon that we as attorneys and prosecutors have to encounter in courts. So the members of public can relax and just enjoy themselves if they can. It's not an enjoyable place, but at least enjoy themselves while they are at the maintenance court, and make sure that they give as much information to the maintenance officer. So how does it start off? They will come into the maintenance officer's office. The DOJ service delivery charter says that the maintenance officer will introduce himself and say what he is over there for and what he will do during the maintenance proceedings. You will explain their rights to them, and you will specifically look at Section 16.4 of the addresses of the parties, that they must give the addresses where they're going to be staying, the civil recourse that the applicant have, the prosecution, blacklisting of defaulters, and the prosecution of defaulters. All of those type of rights of both parties is explained. After the rights, then the maintenance officer need to confirm paternity and will ask the respondent whether he agrees that he is the father of the child or whether DNA paternity should be done. After that, the maintenance officer will inform the respondent of what the amount is that the applicant is charging or requesting from the respondent for the needs of the child. And the maintenance officer will play an active role to see whether he can negotiate a negotiated settlement out of court before they have to reach the magistrate and have to then deal with it in a Section 10 inquiry.
So this is all done in the office of the maintenance officer. This is not done in the informal. The Section 6 is done informally, and it's done in front of the maintenance officer in the maintenance officer's court.
Yes, that is completely
not court,
correct.
the office. Sorry, yes.
Maintenance office, yes, in the maintenance officer's office,
Office.
at the maintenance court. But
That's
yes,
right.
you're
That's
correct.
right. It's just a tongue twist. Okay,
Yes,
so we've established that now. You also mentioned that there needs to be a relationship, the Section 2 or Regulation 2 relationship between the parties. But there's also the question of, and I found that some courts struggle with this. You know what is the definition of care and caregiver in terms of the Children's Act? The reason why I'm alluding to this is because the Children's Act specifically says that any party that has an interest or looks after a child, takes care of a child, could approach any court for some kind of remedy. So the maintenance court is not excluded. So any party that has an interest or cares for the child or is the caregiver can approach the court. So I'm alluding to this just to explain a little bit about what is, in terms of Section 15, the enforcement of the rights of a carer or a caregiver with regards to the child. And that would also bring, because there's no definition, strangely enough, it's not like the Domestic Violence Act where you have a definition of the complainant. The Maintenance Act does not have a definition of what is considered to be a complainant, the person that actually lodged that. So then we have to look at the Children's Act to say, but you know what? What is meant by care and what is meant by a caregiver? Can you just run us through that? Some of the important provisions thereof.
Excellent. That's still that. Unfortunately, we do not have a provision specifically dealing with who are the applicant or who are the complainant in these maintenance matters. Luckily for us, the paper 157, the SA Law Commission paper 157 will deal with a definition of applicant to also include all the people that is included in Section 15 of the Children's Act. So even though we've got this vacuum lacuna at the moment, that vacuum will quickly be, let me not say quickly, I'm being optimistic over here now. As soon as
Very optimistic.
As soon as the Law Commission paper 157 is introduced in Parliament, then hopefully we will have a definition of applicant, which will include a mother, father, a mother of an adult dependent child, an uncle or aunt, or anyone that is taking care of that specific younger child. Even in a case of the child-aided households, we will now be able to have a proper definition that will include all of these people that can stand in for.
And that is very much needed. So it's very much needed to define that, because I also found that, you know what, for example, the mother and the father is working elsewhere in another province, and then the grandparents look after the children. And now I'm confronted with a question: can the grandma or the grandfather, can they approach the court? And most definitely they can, in terms of Section 15, the enforcement of the Children's Act. they most definitely can approach the court. But yet some of the maintenance courts actually turn them away and say, but you know what, it needs to be the biological mother and father. That's why I think, my personal opinion, is it's important to understand the workings of Section 15 of the Children's Act to say, but you know what, who is the caregiver in that specific case? Because that would give the foundation of approaching a maintenance court to claim maintenance for that child.
That's completely true. And your next slide on the definition of care also shows that it includes that grandmother that is taking care of the young child, or whatever the case might be. So it can be more than just the biological parent of the child that can apply for maintenance. It doesn't need to just be the biological parent. I just quickly want to also touch on another amendment that came in operation in January of 2023. The Children's Act was also then amended to also include care and guardianship, because some grandparents have been turned away by the maintenance courts, where the maintenance court said that no, 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 you must first go and apply for care and guardianship in the High Court in order to be able to claim maintenance. You're not the guardian of the child, so therefore you must first get guardianship of the child. Once you got guardianship, only then you can apply. Luckily, that is also now out of the way because of the Children's Amendment Act that came in operation in January of 2023. So there is that provision that also makes provision for the grandparents to stand in as a guardian in the case where they are taking care of that young minor child.
Yet some of the grandparents do have difficulty when it comes to grant or children's grant. If they go in person, if they go to and are wanting to apply, they still have very much, despite all the legislation changes, they still have very much difficulties at Home Affairs to get that. Even just to get a birth certificate of the children, they are met with quite resistance. So that's something that maybe we should lobby and to have some clarification on that in due course. Right, moving on, clarification and explanation of jurisdiction. Obviously, every magistrate court is considered to be a maintenance court, but yes, the question always is, which court do you go to?
Well, it all depends. I believe that every maintenance magistrates court is a maintenance court and should be able to manage or deal with any maintenance matter. Section 16.2 of the Maintenance Act is clear that the maintenance can be dealt with by other courts except the maintenance court, and that is in terms of the Children's Act. Section 33 of the Children's Act makes provision for parenting plans that include maintenance. The Section 161 that includes foster care parents can apply for maintenance in the Children's Court. We all know the divorce court proceedings in terms of Rule 43 and Rule 58. I will not repeat that. The Domestic Violence Act, Section 7.4, makes provision for emergency monetary relief funds. So all of these type of courts can also, and most of these courts are also available at the Magistrates Court, like the Domestic Violence Court is situated in the Magistrates Court, and the regional court that can make a Rule 58 a divorce order is also situated in the Magistrates Court. So all of these courts sitting in the Magistrates Court have the function or the authority, the statutory authority, to make maintenance orders.
Why is it not done? Because I've been to domestic violence court. I'm there quite often, and then they just turn me away and say, you know what, deal with it in the maintenance court. Is there a logistical problem? Let me ask it this way: is there a logistical problem between the two departments or the two courts? Obviously, they use the JDAS system and the other system that they have, but do the courts talk to one another, or is that where the barrier is? The resistance that they have?
No, that's not what our or my out of my experience. My experience is that The domestic violence court do not want to get involved in emergency monetary relief funds and all of those things because they feel that a proper inquiry was not done. And because it's not a proper inquiry that was done, how can they make that a finding? The same with
So they
with
rely
the
on Ilsley versus Lachoba. That case of Ilsley versus Lachoba, there should have been a investigation done before they could make an order.
Yes, and that's one of the reasons why the children's court, domestic violence courts, and all of these courts do not want to make these orders. But the High Court, which is a higher court of instance, they've got no problem when the respondent makes an offer and say, "Okay, I can afford 5,000." Then the High Court judges will make those orders. Why
Mm-hmm.
the lower court magistrates have a problem to make those orders is unclear to me, and I still don't understand why they do not want to enforce the statutory powers that they have to make those orders. They still don't believe that they are properly equipped to make those decisions.
And I mean, they are a creature of statute, so they have to abide by the statutes and everything. So there's actually no reason or no justification why they should not be able to make those type of orders. Just to circle back to jurisdiction, so if applicant goes to court, they can use which court? They can use the magistrate court in the area where they live, where they work, or where they carry on business, or where the child is. So those are the
Okay.
three. It's basically
Yes.
any place where you are physically present, you can use that court. Obviously, it might
Yes.
be more convenient if you approach the court where you work. Because you have to be there during working hours or so, but that court would have jurisdiction. So there might be an instance where there would be more than one court having jurisdiction.
Yes. And the Maintenance Amendment Act 9 of 2015 made it more clear that mothers can apply for maintenance, which is more convenient in a case where she's going to work in a different area. And there is a maintenance court closer to a place of employment, then why can't she access it at that court? So I'm glad that the Maintenance Amendment Act 9 of 2015 made it more clear that you don't just have to apply at the court close to where you're staying, but also close to where you're working in that case. And if I can make just quickly add, Eugene, also, if you have a High Court divorce order, that High Court divorce order can be amended by the maintenance court. You are not bound, and that's the nice thing about the maintenance court. The maintenance court's got extraterritorial jurisdiction, which means they've got the authority to go beyond and even amend a High Court order. So I just want our listeners to take note of that provision too.
Very important, very valuable. Thank you for that. Thank you for that. Right. So, just as an outline of how a Section 6 inquiry is conducted, you in the courts, you are one of the most brilliant maintenance prosecutors out there. Well, most definitely in the Western Cape for sure. So, in your view, can you give us an overview of an outline of how should a Section 6 inquiry be conducted? Because you know what, there's some courts they follow their own rules, but in your view, reading the act, what is the outline of how a Section 6 inquiry should be conducted?
Okay, all of us know that the complaint is lodged and the J101 is then given to the maintenance clerk. It is being investigated, it's being captured and recorded by the maintenance officer. Then the informal mediation, Section 6, is going to start and the negotiation process will happen. In most cases, maintenance officers just go straight to the negotiation. They do not introduce themselves. They do not explain the rights of parties. They do not deal with confirmation of paternity, which might become an issue later on when there are non-compliance with that specific order. But for me, whenever I do maintenance inquiries, and I love doing maintenance inquiries, and I don't know why prosecutors are away from it, but it's the most informal mediation process that is so nice where you can engage with people without having to have the law of evidence or any statute or anything with you. As long as you explain the basics, you show them their rights, you show them the confirmation of paternity, and then you start the negotiation process. Then you, in a case where he agrees to an amount, make that a J214 consent order. All of that is taken to the magistrate, and the magistrate can even sit in chambers. He doesn't have to be in court, can then make that order. In a case where the magistrate is not there that specific day, then all you need to do is just make sure that you have the J214 consent order drafted, and the signatures. Below the signatures, I always put the name and surname, cell phone number, email addresses, and all of those details below the signature to make sure that the magistrate can call that person and find out, listen, that you signed this document yesterday or the day before, I wasn't at court, or whatever the case might be. And once that is confirmed, there's nothing that stops the magistrate from completing a J168 court order and make that specific J214 consent order a court order. And the court can do that on a J168 where the court was not present on the day that the J214 consent order was signed, and that court order will then be made an order of court, and from there onwards, the court will or the respondent will have to comply with that order. In a case where there is no consent, then obviously we will get to the Section 10 inquiry before the magistrate. That's the more formalistic, legalistic uh, process that I think at times are being made too legalese, with bundles and all of those requirements that the presiding officer might want to put in place. I believe that if you have your J101 or your J107 and you've got all the supporting documentation, all of that can be submitted to the court. Having these bundles, especially if the person, the applicant, is not legally represented by an attorney, then it becomes a nightmare. And I just feel that if a presiding officer or magistrate play a more active role in making sure that he receives those documents as it is being presented by the maintenance officer, then
If I
we
cor-
can get.
if I recall correctly, isn't there in the DOJ Code 26 provision that the clerk of the court, clerk of the maintenance court, needs to make the copies for the bundles? If I'm not mistaken.
Yes, that is true, but sometimes these pieces of legislation is just muddled down, and then it becomes, especially the policy documents. Uh,
Mm.
you'll find most of people do not know the DOJ Code 26 of 2015. Not even maintenance staff sometimes know this specific document. So even though it's there, sometimes some of our colleagues do not even look at it. Prosecutors don't even know that there's a DOJ Code 26 of 2015. So if the magistrate says that he wants bundles, then bundles it will be, no matter who must copy it and who must make provision for it. It's not even where they are assisting the applicant to just make sure that the calculations are correct, which is on page 13 of the DOJ Code, and not even that is being complied with.
So, and it's also important to note that the maintenance officer is an unbiased person. It's an
Yes.
unbiased person that do not take sides. They do not take sides for the mother, because there's a general perception of the public that the maintenance officer should take the side of the mother. And that is not the case. One of the tasks of the maintenance officer is to scrutinize the documents, get the parties in front of them, try to do an active negotiation process in order to resolve the matter, and only then transfer the matter to court in terms of Section 10, if the parties could not resolve the matter, or if there's a dispute on facts. So it's very important to note that the maintenance officer is supposed to be unbiased, and they are there to assist even the unrepresented complainant. Also, in terms of the Section 10, the magistrate is not like a normal magistrate sitting in front in a criminal matter or a civil matter, because it's considered to be sui generis, unique in nature. It's a combination of civil and criminal, that the maintenance magistrate actually has an obligation and a duty to assist unrepresented people in court. So there should be no reason for any complainant to be scared and to be afraid of going to court, because they will get help, and they can insist, that's one of their rights, they can insist that they get help unbiasedly from all the parties. Anything that you want to add on that?
Well, I don't want to repeat what you already said, but the maintenance officer act in the best interest of the child in terms of Section 7. So there is no sides that the maintenance officer will be choosing whether the applicant he is there for the applicant or for the respondent. The duty of the maintenance officer is to look at the best interest of the child in terms of Section 7 of the Children's Act, and that is the only duty that the maintenance officer has, and not to assist or to be seen as the attorney for the applicant or siding with the respondent. That should never happen.
Coming back to base interests of the child. Now, dad says he's not the father. So now we sit with a Section 21, and it's usually done. The issue of paternity should actually not be dealt with in a Section 10, because it should have been dealt with during the Section 6 inquiry, the informal query, starting with the negotiation process when both parties in front of the maintenance officer. So it should not actually go to court, and only at a later stage, then the dad decides, you know what, he's not the father, because that might be seen as a delay tactic. Can you just run us through obviously Section 21, and then my all-time favorite, Section 36?
Yes, as far as I agree with you that in the Section 10 there should not be any dispute pertaining to Section 21 paternity. That should have been resolved during the informal proceedings. That's why I say it's so important that you have your rights of parties and your confirmation of paternity that is being sorted out right in the beginning of your Section 6 informal inquiry. Then you will not have to deal with it anywhere else, not in a Section 10 and not in a Section 31 prosecution, ever should, while the accused is on the witness stand after defaulting action, then only you say, yeah, but I'm not the father, and only then request paternity. That will be too late. That's why I would like to urge the maintenance officers online listening to us today, please make sure that you've got the rights of parties form completed during the Section 6, as well as the paternity form completed. Okay, so once we're there at the respondent deny paternity, then Section 21 will kick in, where the maintenance officer will then conduct a DNA test, and the DNA test will then conclude
Surely
whether
it's not the maintenance officer conducting the test.
yes, the maintenance officer ordering that the specific parties will be going. Thank you, Dean, for the paternity test. The maintenance officer play an active role in the sense that the maintenance officer will contact the service provider and will then arrange for the blood of the parties to be taken. That is the blood of the baby or the child, as well as the blood of the mother and the blood of the respondent. The 3 samples of blood has been taken, and then it will be analyzed by the service provider. Once the service provider analyzed it, then it will then conclude whether he's the father or not. If he's not the father, then that's where the case will end. If he is the father, then obviously the matter will continue from there onwards. Paternity test takes a period of weeks, and it's not immediate. Therefore, what I usually recommend to maintenance officers, as soon as the person say that he is not the father, and it might be a delaying tactic, I'm not saying it is, but when the father says that he is not the father, while you've already done things that will describe him as the father, then Section 36 of the Children's Act will kick in. And that is a presumption of paternity, and where the court will regard that specific father as the father based on certain information that the mother will give. Number one, that they had a sexual relation, and once she told him that she's pregnant, what his actions were afterwards, either purchasing paternity clothing, taking the mother to his family and telling and informing his family and her family that he is the biological father of the child, all of those things will play a role in order for a maintenance officer then to invoke the provisions of Section 36, and while they're waiting for the Section 21 DNA test results or the DNA test to be conducted, that he can or she can order a Section 10(6) interim maintenance order while they are awaiting for the DNA paternity test to be conducted.
Quick question. Do I understand correct that it is the maintenance officer that is actually empowered to invoke Section 36 of the Children's Act, or is such an order made by a magistrate?
Yeah, the magistrate will eventually make the order. Technicalities, but you're correct that the maintenance officer will then do his inquiry in terms of Section 6, busy with the inquiry, and ask certain questions, the questions that I asked earlier, sexual relations, his position after pregnancy and after hearing that she is pregnant, and his actions afterwards. Take all of that to the magistrate and ask that the presumption of paternity in terms of Section 36 be invoked, and that the father is presumed to be the father until there is evidence to the contrary in Section 21 that shows that that specific person is not the father, or whatever the case might be. Thank you.
Okay. Before we get to the rights when it comes there, I would just want to circle around and come back to, and I think interim maintenance orders. That was my next question. Before we get to the service delivery charter, which we basically touched on and discussed earlier, can a Section 10(6) interim maintenance order be made as soon as the presumption of parenthood, fatherhood, is invoked, or Section 21 is invoked? Can the court then make a provisional order, interim maintenance order, based on waiting for the results of the DNA?
There is nothing that stops the court from making that order. Whenever I do those type of cases, and there is a denial of paternity, and you can so easily see in the mother, she is so stunned that he all of a sudden now invoke a denial of paternity, that I with confidence make those orders and will then make an interim order, because some of the respondents that I found will come up with, they don't have the amount of 2,500 that it costs for paternity now, and therefore needs 2 months or 3 months to get all of that money together in order to pay for paternity test. But what about the child? Therefore, if there is sufficient grounds to, number one, believe that that specific father is the father based on Section 36, and number two, the mother will suffer undue hardship because of this
Postponement or delay.
continuous postponements or remands and delays. Therefore, the court can make that decision. But I always warn the mothers that listen, in the event where these tests comes back negative, that he is not the father, then the father will have a civil claim where he can claim that amount back from you, where it's found that he is not the father. But in most cases, they know that they have been in a sexual relationship with that person, and they are 100% sure that he is the father. I've got no problem making an interim order in terms of Section 10(6), even in a case where he denies paternity, and will make that order valid until the paternity tests are being then concluded.
So the interim, the 10(6) interim order can be asked for or requested at any time that there is chances of a remandment or a postponement, and that the mother would have undue or suffer undue hardship as a result thereof. Then she can actually ask, I want, I need interim maintenance in order to tie me over because the postponement is going to happen and it's not my fault. So at any stage that could be used.
Yes, that's completely correct. 10(6). Can I quickly just say the provisions of Section 10(6)? Sorry, Eugene.
Yes, sure.
Section 10(6) says that the maintenance court must limit the number of postponements and the duration of those postponements. That is the reason why a applicant can apply for an interim maintenance order, because you will suffer undue hardship because of all of these postponements and the duration of those postponements.
Fantastic. Consent orders, you already mentioned consent orders. So if the parties sit in front of the maintenance officer, and they come to some kind of agreement, then a J214 could be filled in, could be completed, and the magistrate would basically just then make an order of court. But it could also happen that this happens during the course of a mediation, for example, where the parties go for mediation, or they come to certain kind of agreement during, just talking around the house, or the families get together and they make arrangements. Then they can actually complete a J214 form, which is a downloadable form. So it's a available form. It's not one of those forms that you cannot download and it's just for the magistrates. So it's a downloadable form that anyone could have access to, and then can complete that form and take that to the maintenance officer, together obviously with an affidavit confirming the contents of the J21 form, and there would be no reason then for the magistrate to endorse that and make that an order of court. Am I correct in my understanding with that?
You're completely correct, but let me just warn some of the online listeners. There are some courts that believe this J214 consent order is the most holy document that there is out there. It can't be completed by anyone else but a maintenance officer. That's completely not the truth. And it can be, and sometimes attorneys comes to me and say that they've concluded the agreement between the parties. His client is willing to settle on this amount. The applicant is happy with that amount. Can we make that an order of court? And I've concluded cases with attorneys that completed the J214, and I don't see that as a holy document. I see any person that can help me as a maintenance officer to do my work quicker and more efficiently. Why am I going to hold it back and say, no, I must complete this form? Unless I'm so zealous and want to get more work, then obviously then the maintenance officer can do so. But the J214 can be completed by an attorney, by a mediator, by anyone, and that mediation agreement or the consent order, as in any divorce order, can just be added to the court order, and the J214 can be added to the J168 court order, but there is no such thing that J214 cannot be completed by a mediator or by an attorney.
Good, thank you for that, the clarification. So next question would be what happens if the respondent or the father do not show up at the maintenance court at the Section 6 inquiry? That question has been asked probably a million times on my Facebook group. So in your words, coming from you, because you're authoritative, you're from the NPA, what is your answer? What could we do?
Okay, where the respondent was summoned with a Regulation 3 directive, in those cases, if the Regulation 3 directive was served personally on the respondent, there is nothing that stops the court from issuing a warrant of arrest in terms of Regulation 3, subsection 3 of the maintenance regulations, or 1361 of 1999. That is clear. The only issue is where the maintenance officer used any other means that he deems fit. That's in terms of Regulation 3. Regulation 3 says that a maintenance officer can use any means he deems fit or she deems fit. In some parts of the country, Beaufort West is my favorite place in the Karoo. My colleague over there will pick up the phone while the maintenance applicant is in our office, and she will call the respondent and tell him that the applicant is there. When can you come to court? If he says that he can come to court on Wednesday, then she will set the matter down for Wednesday. If he doesn't appear on Wednesday, then you can go and ask for a warrant of arrest in that specific case. But regulation says that, says that you must keep proper record. All the maintenance officer must do is keep up a record in the maintenance file. I called the respondent on this date on this number, his cell number, and he confirmed that he will be at court on Wednesday. If he's not at court on Wednesday, then obviously the court can ask for a warrant of arrest, or the maintenance officer can ask for a warrant of arrest. If he is summoned any other way, like via email, and there was no feedback from him, or whatever the case might be, sometimes these courts will be compelled to issue another regulation directive or a Section 9(2) summons. But Ilsley versus Achoba say we cannot issue a Section 9(2) summons unless the investigations have been completed in terms of Regulation 3. You want me to explain further as far as
No, that's perfect. That's perfect. We don't want to go into too much details because we will address this, the whole Ilse versus Choba, and definitely on a next webinar. Okay, right. So what happens if the respondent or the father did not bring all the required documentation to the court? So obviously there's certain provisions, the Section 7, Section 8, and Section 9, which forms different along the process of moving towards a Section 10 formal inquiry. If you could just briefly, we're basically running out of time. We've got about another 8 or 9 minutes. If you could just quickly run through Section 7, 8, and 9, and when is it used and when could it be used?
Okay. Section 7 is being used when the maintenance officer will instruct the maintenance investigator to get other information that includes the ITC report, e-notice, a wind deed search, or bank statements, or other affidavits that they might need. All of that can be done in terms of Section 7. If there are any other witnesses that will be needed to be summoned, then we do it on a Section 9(2) summons, and that's where the maintenance officer will then give instruction that certain people will then be requested to come and testify about a book or statement or document. In the case where we summon the banks, then we use Section 8. Then we will ask that a Section 8 subpoena be issued for the bank or for the financial institution or for Vodacom or whatever the case might be, in a case where we would like to get some detailed records or bank statements from them. And that will be to discuss the financial position of the respondent. In a case where we want to get the HR salary slips of him, then we will use Section 8 of the Maintenance Act. Section 9(2) summonses is the one that we use more to summon a specific person that will give information on books or statements or documents that is needed for the Section 10 inquiry. And yeah, let me stop there.
And this is, say for instance, with other words, just in order to confirm. So if you believe that there's documents that need to be submitted, because obviously the maintenance officer would not know what documents there might be, but you as a mother might know and say, but you know what, he's got Capitec Bank, or he's got that, or he's got this and the other, and he does actually have a work. And then so it's up to the complainant, to the mother, to approach the maintenance officer to say, but you know what, I know that he has these means, Capitec Bank or whatever. So then Section 8 could be invoked. So there's some reliance and some dependence on the assistance of the complainant to assist the maintenance officer in getting all these information to court.
Yeah, I believe that the applicant is our main source of information. She is our wealth of information. We need to capitalize on that while she's in the maintenance office.
Absolutely, I cannot agree more. Right. So what other remedies are there available during a Section 6 inquiry? Like you said, these acts do not operate in silo. I mean, while you're busy with your maintenance application form or application process in the Section 6 inquiry, there might be criminal proceedings in terms of Section 305. There might be an interim or even a final domestic violence protection order that might be in play. And then, of course, your favorite would be the evidence portion in terms of the Criminal and Related Matters Amendment Act. Can you just give us some context, some information regarding that?
I will start with my favorite first and then move to the others. The Criminal Law Amendment Act 12 of 2021 was or commenced on the 1st of August last year, 2022. As from August 2022, mothers that are in a domestic relationship and scared of the respondent or have a domestic violence order against the respondent can, in those specific cases, ask in terms of Section 51C or in terms of Section 51A for intermediary and 51C for a audio-visual link to be created between the maintenance court and another venue where she can be sitting. She can even be sitting with an attorney in his office and then have an audio-visual link to the court where she will then be able to testify. So that's another means where the legislators somehow want to assist people that are vulnerable women that are in domestic relations where they've been abused, where they will have that facilities available to them where they can testify via the use of an intermediary 51A or via audio-visual link in terms of 51C. The other means or that you have over there, Section 305(4) of the Children's Act 38 of 2005 says that where a parent do not fulfill his parental duties, then in those specific cases, the parent will then be held liable, criminally liable when he doesn't comply with it.
Fantastic. Thank you so much for that. If we can just see what is the next slide. There we go. A brief discussion on your view. I've put an orange there because I want but I'll wait for next session discussing the mediator's orange. Your view in probably 2 minutes on mediation as a form of dispute resolution in maintenance matters. We see that that's going to happen. It's in the Maintenance Amendment Act. It was in paper 157. So it will be pushed through. Maintenance will, and I think there's still very much benefit for that, for ADR, for alternative dispute resolution when it comes to maintenance matters. Your view on
well, I'm very excited that maintenance officers will not be overburdened having to get maintenance orders in place. That will also now be shared with mediators in terms of the ADR bill, in terms of the proposed amendments to the Maintenance Act by the Law Commission in paper 157. So there's a lot of exciting things that's going to happen in the South African fora pertaining to maintenance, and mediation is playing a pivotal role in making maintenance more accessible, more quicker for the people out there that can access the services of a mediator. So there's a lot of exciting things that's going to happen in a few months in South Africa.
Fantastic. And we will definitely be discussing probably 1 or 2 webinars or lunch and learn specifically on mediation and maintenance matters. Now, this is just basically the overview, what we've talked about. That is, what a complaint, clerk of the court goes to the maintenance officer, you do your Section 6 inquiry, and then your the Section 10. That's just the structure. That's just in summary of what has been said today. I believe it was very insightful. It was, Dion, it was, as always, it was absolutely fantastic talking to you. Thank you so much for joining us today. And probably, I think next week you will be joining us as well for a Section 10 inquiries, discussing that as well. But thank you so much. I really appreciate all the insight, all the knowledge that you have and you bring and you share so freely with all the people. Thank you so much.
Thank you, Eugene, and thank you to our listeners that are online. I hope that you've learned something from today's session.
Thank you so much, and enjoy your evening further, or your